In October 2024, the government unveiled its Employment Rights Bill, which is currently making its way through Parliament to become law. This bill introduces major reforms to workers' rights. So this podcast is part of a series of podcasts discussing some of the main provisions of the bill, and this is part 4 of that series. We've already discussed a lot of the changes, such as unfair dismissal, collective redundancies, changes to fire and rehire practices, and 0-hour contracts in our previous podcasts. If you'd like to listen back to these episodes first, you can find them on the Clarkslegal website. So my name is Amanda Glover. I'm an associate in the employment team at Clarkslegal.
And I'm Shauna Jones, solicitor in the employment team at Clarkslegal. Today we will be discussing the significant changes the Employment Rights Bill will be making to industrial relations and trade union rights. For employers, especially those in sectors with a strong union presence or where there's rising union activity, the changes could fundamentally shift how you manage collective relationships, workplace access, and industrial action going forward.
Yes, that's right. And it's worth flagging that as the bill is making its way through Parliament still, it's subject to amendment. So some provisions may change by the time it's enacted. And we've already seen amendments being proposed lately.
So you may want to grab a coffee. This episode is going to be packed with information. So let's get into it. Let's start with statutory union recognition. As it stands today, if a union wants to be recognised for collective bargaining, they need to show they already have at least 10% membership in the proposed bargaining unit, and also that a majority of those employees in the proposed bargaining unit are likely to support recognition. The Central Arbitration Committee can only then order recognition if either 1, at least 50% of the bargaining unit are union members, or 2, a ballot is held, in which a majority of votes cast are in favour and at least 40% of all workers in the bargaining unit vote for recognition.
Yes, but under the bill, that bar is dropping significantly. So the 40% turnout threshold for a ballot will be gone. And the need to show likely majority support for an application is also gone.
And here's the kicker. The government would have the power to reduce the required union membership threshold for an application from 10% to as low as 2%.
Yeah, and that could completely change the game. So, for example, in a workforce of 500, as few as 10 people could kick off the statutory recognition process under future regulations. And as long as the majority of those voting in the ballot voted in favour, recognition could be granted. And I want to highlight here that it is a majority of those voting that is taking into account, not a majority of the bargaining unit. So you could have a fairly low turnout in the vote, and as long as the majority were in favour, the recognition bid would be passed.
Yes, and add to that the change around voter eligibility. Employees hired more than 10 days after the union applies to the Central Arbitration Committee won't count towards the numbers and won't get a vote.
So that could create a real incentive for unions to move quickly and for employers to stay alert. All of these recognition changes are expected to come in by April 2026, so quite soon. So, next up, let's discuss union access to the workplace. Under current law, unions can't just walk in. They would need the employer's voluntary agreement or a central arbitration committee order tied to a recognition ballot.
But the bill changes that completely. Union officials would get a general right of access to workplaces for recruitment, organising, and collective bargaining. Not industrial action planning, to be clear, but still a significant expansion.
Yes, employers will have to either negotiate access agreements or face potential CAC imposed terms for access. And it's not just about physical access, there's explicit provision for virtual or digital access too.
That's right. So we're not just talking about someone showing up at reception. This could mean digital meetings, online chats, even targeted communications to employees. It gives unions a potentially very effective set of tools.
And for those employers who don't play ball, the Central Arbitration Committee will have powers to order compliance and even impose financial penalties. So details of the process, including the default access terms, are still to come in future regulations.
But again, the timeline is October 2026. So while there's some breathing room, this is definitely one to start preparing for now, particularly around internal policies and site security protocols. Moving on to another change, and this one might fly under the radar, but it's important. Employers will be required to give new workers a written statement when they start work. Currently, employers have to give workers certain information when they start work, known as a Section 1 statement. But these new rules require there to also now be a clear statement for workers that they have the right to join a trade union.
Yes, so currently collective agreements have to be referenced in the Section 1 statements, but this new right will go further. So it will require employers to give this new statement at the same time as the Section 1 statement, but also to provide it at other prescribed times to be confirmed. And then a failure to provide this will be treated in much the same way as a failure to provide a Section 1 statement.
The exact wording will be set in future secondary legislation, but the changes are nevertheless expected from October 2026.
Okay, so now moving on to a change that's really raising eyebrows. So the bill proposes repealing both the Strikes Minimum Service Levels Act 2023 and most of the Trade Union Act 2016 immediately after the new bill comes into force.
So we're talking about scrapping some major limitations introduced over the last decade. Things like longer notice periods for strikes and the expiry of industrial action mandates after 6 months.
Yeah, all of that gets rolled back, and instead the bill would allow industrial action mandates to last for 12 months. Notice of industrial action would drop from 14 days to 10 days, so less time to prepare. And perhaps most significantly, electronic balloting would be allowed.
Which could make balloting quicker and more responsive for unions. It's worth flagging that e-balloting is expected to kick in by April 2026, so that one's not immediate.
For employers, as mentioned, that means less lead time and potentially more frequent or spontaneous industrial action. And that's especially true in heavily unionized sectors like transport, healthcare, and education.
Let's finish with protections for trade union members and representatives. At the moment, there are already laws protecting employees from being dismissed or treated unfairly because of their trade union membership or activities.
Yeah, and the bill strengthens that. So, for the first time, it would make it unlawful to subject a worker to any detriments short of dismissal for taking part in protected industrial action.
And on top of that, we get a new statutory role, the Union Equality Representative, whose job it would be to promote equality, advise members, and work with employers on equality issues. They'd be entitled to paid time off to carry out those duties.
And employers would also be required to provide reasonable facilities to support all union reps of recognised unions. So, think meeting rooms, access to systems, possibly even equipment. Again, with these changes, they're expected to come into force in October 2026.
So, in summary, what we're looking at is a legislative package that lowers the bar for union recognition, strengthens access rights, expands worker protections, and rebalances the industrial relations laws more in favour of trade unions.
Yeah, and for employers, particularly those in unionized or union active sectors, this is really a wake up call. You've got some time, but not forever. So start thinking now about your policies, your employee relations strategy, and your risk profile. And you may also want to think about your current employee representative bodies, such as employee forums, and whether they're fit for purpose in capturing employees' voices.
And keep an eye on those secondary regulations. They're going to shape how a lot of these changes work in practice. As ever, we'll be keeping clients informed as the bill moves forward.
Okay, that's all for today's episode. If you've got any questions about how the employment rights bill might affect your organisation, or if you're already seeing increased union activity, do please get in touch with the team.
Thanks for listening. Don't forget to subscribe for more legal insights, and we'll see you next time.